Thank you so much. I will start and then leave the floor to Professor Pollicino. We managed to present different parts of this presentation, even if, of course, this is a joint effort we made, and it's also the result of many years working together on such topics. Thank you so much for this invitation. That's absolutely a pleasure, and it's a privilege to be here and to have the chance to share with you some preliminary thoughts on the content of our chapter, a chapter that, as you know, and as you said, will be focusing on the active profiles of freedom of expression. So looking at the activities and the different forms which are covered by constitutions in Europe regarding freedom of expression. What we are expecting to do today is to share basically one of the many profiles we would be looking at, basically sharing also the methodology we are trying to implement, looking from a comparative standpoint at various possible jurisdictions, looking at different framing of freedom of expression, trying to focus on how constitutions are protecting the active profile, meaning the activities that the speaker is entitled to under the relevant constitutional umbrella, and then try to understand which are the most important challenges that constitutions and also supranational law, thinking about the European Convention on Human Rights and the system of the legal system of the European Union are facing. And among others, we will look at the challenges deriving from the new characterization of the public sphere, and we will mention something about the rise of the digital age, which is not, of course, the only scope, let's say, the only scope we are going to examine. We know that there are chapters focusing on the regulation of social networks and regulation of the internet, but we will try to specifically understand how the emergence of the digital sphere and the specific feature that are the distinguishing feature of digital sphere will reflect in the understanding and also in the protection of what we will call the freedom of the speaker under the different constitutional umbrella. And so today we will be very specific, very closely look at this in order to basically let emerge our methodology and try to share our view. If you can go ahead to the second slide, I will briefly explain which are the main profiles we're going to touch upon. Yes, perfect, thank you. So basically, we move from the question, how do constitutions and supranational law frame the protection of the active side of freedom of expression? So basically, trying to compare what constitutions most notably provide. That's an important point because it allows us to understand many important features to keep in mind in a specific age when we need to basically address many important technological challenges. We will probably move from the idea that there are many profiles. So we will try to outline how many rights are covered by the relevant constitutional umbrella. We will also point out the existence of separate means protected by constitutions. Sometimes we have constitutions including open-ended clauses, making reference to the different possible means that can be used in order to exercise freedom of expression. In other cases, we will have more difficulties because we see maybe the specific reference made by the Constitution to a specific mean. And so it also triggers a question that is a question on the possible existence of different freedom of expressions. What do we mean for that? The existence of possible different constitutional coverages for different means. I'm making the example of freedom of the press that in certain constitutions, for instance, the Italian one, seems to enjoy a very particular protection, a very strengthened protection compared to other profiles of freedom of expression. This is also relevant. It is also relevant for us to look at the limits that may depend on the specific, of course, constitutional history of each country. And we will make reference, for instance, to Germany when there is a very important attention paid to dignity, the protection of human dignity. And also another very important point, another key point we feel we have to address in this comparative overview is the distinction between the private and public sphere. That will be specifically a point on which we focus today, because as we know, when it comes to constitution, we mainly are dealing with vertical publications stemming from the constitution for the state and the state actors. We know that there is certain case law extending to private actors the obligations to protect certain human rights, including freedom of expression. But of course, the existence of a new public sphere, when we see the role of private actors, namely social networks and online platforms, led us to question if this is a very key issue to be addressed by constitution. So that's basically what we will try to do, questioning if it's a matter of wording, and I will show you the very provocative, I hope thought-provoking image that we'll see in the next slide, in order to say, let's look at the constitutional wording and let's try to understand if it's still relevant, if there are some challenges that are requiring to adopt a new framing, a new wording for the constitutions. In Italy, for instance, we had a large debate concerning the possible inclusion of the internet and new digital media under the constitutional umbrella, including a specific provision that are challenges that I think are shared by other jurisdictions. And today, as I said, the focus will be specifically on the right to hold opinion and to share information and ideas, and precisely looking at the problem of disinformation. Why the problem of disinformation? Because it shows the fact that individuals generally have the right to hold opinions and to share what they think, basically. But of course, we feel that the existence of the new digital sphere is creating further challenges and is probably making things a little bit different compared to the scenario that we could witness in the real world. That's basically our outline, and maybe it's a bit demanding, but we will try to go through the different points. We can go to the next slide. Thank you. Okay, thank you. This is an interesting basically scene taken from an Italian movie, very well-known Italian movie. Professor Pollicino was surprised that I mentioned this movie because he knows that I'm not an expert on this, but it's a very interesting movie by Nanni Moretti, a famous Italian film director. And this is a scene taken from Palombella Rossa, when this guy was basically stressing this important sentence: words matter. Le parole sono importanti. In Italian, words are important, basically. And it was, as you can see in this image, it was trying to stress this concept, just to say, hey, we need to be very careful about the words we use in everyday life. Why we wanted to start from this? Because if we go to the next slide, thanks, we can notice that constitutions use, of course, different wordings. There are different important differences that can be spotted if you look at the different possible constitutional provisions. In the I don't see the next slide. I don't know if it's a problem. Okay, okay, thank you so much. Here in this slide, we try to do something very basic, something, I mean, it's not a very demanding effort, but we wanted to start from the wording, start from what constitutions say, because sometimes we may probably underestimate the fact that from what constitutions say derive important consequences. We first tried to address the Constitution of Germany, the German Basic Law, and then compare it to the Italian Constitution and compare them with Article 10 of the European Convention of Human Rights. As you know, it's the general umbrella we are considering in Europe. And we tried also to draw a comparison between the European understanding of freedom of expression and the American understanding, looking at the First Amendment. What we can notice, if we look at Article 5 of the Grundgesetz in Germany, is that sometimes there are specific references. If you look at Article 5, you will notice that looking at the active profile, the Constitution is mentioning the right to express and disseminate opinions, speech, writing, and pictures. So that's with reference to specific means, including also the right to inform himself or herself from generally accessible sources, the right to research information. It's also mentioning the right to the freedom of the press and freedom of reporting and freedom of arts and sciences and research and teaching. So we said that our focus will be on the right to hold opinions and to share information and ideas. And we feel it's interesting to notice that the German Constitution, it's basically focusing on the right to express opinions. This is interesting because we discuss very frequently the difference between opinions and value judgment and statement on facts. And we noticed that in the recent scholarly debate, this has been a very hot topic in order to try to draw a distinction between what is subject to constitutional coverage and what is not, and accordingly, what states can prohibit or interfere with, and what states cannot interfere with or prohibit. And we noticed that, for instance, in Germany, this was a problem, and we will later on say a few words about this. To the extent the fact that Constitution only referred to the right to express opinion made it necessary for the German Constitutional Court to interpret broadly this specific wording in order to go beyond the mere expression of opinions, but also cover many important activities that maybe prima facie cannot be reduced to the only dissemination of opinions. On a separate side, we look at Article 21 of the Italian Constitution, that in our view include a very far-seeing clause, a very open-ended clause that recently, of course, was called into question with respect to the debate on the constitutional coverage of the internet, because it refers to the right to express opinions and thoughts. So it's a more open-ended clause in this. And looking basically at the right to express the thoughts in writing, by words, and by all other means of communication. This is a very important point, very sensitive point, because it's an open-ended clause, which is basically opening to a very broad constitutional coverage. At the same time, however, the Italian Constitution seems to attach a very specific attention to the press. If you look at, we didn't mention here all the paragraphs because there was no way to do that, and it's out of scope, but the Italian Constitution is mentioning mainly the press, except for the first paragraph when we basically notice that they are using this very general clause. And this made it a very debated issue in the scholarly community, whether this means that freedom of press enjoys a special status, a special constitutional status. This is enjoying more protection, it's a strengthened protection compared to the other possible means of communication, the other possible means for expressing thoughts and opinions. Let me also add an important thing. What the Italian constitutions managed to let develop and let emerge in this very specific provision is the importance of pluralism. That is not mentioned here. If you look at Article 21, you can probably only notice a provision that is not mentioned here on the financing of the press, that is probably related to transparency. So it's not per se pointing to pluralism as a constitutional obligation, but what the Italian Constitutional Court has done so far, especially over the last 2 decades of the last century, was to stress the importance of the pluralism in the context of the television industry, in the context of broadcasting activities. And this is not, let's say, written in the Constitution. If you look for the principle that is named as pluralism, internal and external pluralism, you don't notice the existence of such principle. But the Constitutional Court managed to look at the right to seek information and the right to receive information, and managed to let emerge this important added value that is not written in the Constitution once again. On the other one, you have Article 10. It's very well known. We will say a few words about this. But let's try now to compare this scenario, this comparative scenario, with our First Amendment of the American of the U.S. As you know, it's a completely different framing. It's a completely different framing where we are not looking at a constitution that is establishing specific situations enjoying protection as such as fundamental rights for the individuals, but we are mainly and basically looking at a prohibition on government to introduce any possible abridgment of speech. And this is an important point we want to address. The fact that we have such wording makes it, of course, different the latitude of the protection that this right enjoy in different constitutions. The fact that we have a general ban on government to introduce restrictions and basically a more elaborate case law in order to establish under which circumstances this freedom can be limited, of course, also reflect in the different degree of protection. Because while in Europe, we have certain rights and we can say, okay, the freedom of the speaker is the freedom to exercise a certain set of rights, even if, as we've seen, we have open-ended clauses and more closed clauses. In the US, of course, this has definitely a bigger impact. We can go to the next slide in order to highlight another interesting point that we will dig into, the possible justifications of freedom of expression. This is a quote taken from a very interesting article by David Strauss, 1993, so not confronting with the rise of digital technologies, but basically an important point we want to address is the kind of justification for freedom of expression. Right-based justification or a structural justification? Are we looking at individuals? Are we looking at the individual and the variety of rights she is entitled to under constitutional law? Or are we looking at something that is beyond the individual, a structural justification, a society where freedom of speech is an inherent value of the legal system? And then we look at the structural justification that is not looking at the right to speak as something that is basically granted to the individual because the individual want to share some thoughts and opinions, but something that is a distinguishing trait of the legal system, where we see that system is a system that is supporting freedom of speech and that it's creating conditions for individuals to exercise freedom of speech and supporting it. So according to Strauss, there is probably more a structural justification in the US. And this is another point we want to address. In our view, if we look at the constitutional framing, the constitutional wording, it seems probably that we are looking at a right-based justification. We are looking more at specific situation individuals are enjoying and are, of course, granted to under the relevant constitutional umbrella. We can go on with a few remarks on the different constitutional provisions that we just mentioned. Just to briefly try to make clear the points in which we want to delve into and to dig a little bit more. The fact that, as we said before, in the U.S. Constitution, we have a general ban, so it's up to the jurisprudence, meaning case law, and it's up to courts to determine which are the possible restrictions, determine which are the conditions under which freedom of speech can be subject to restriction. This is, of course, has important consequences in terms of legitimacy, in terms of determining what lawmakers and regulators can do when it comes to, you remember very well, I think, the Reno versus ACLU case. You remember very well the attempts made by government in the US to tackle certain problems and the very important reluctance showed by courts in the US to say, no, you can't restrict freedom of expression this way because that will be disproportionate. It will interfere with the constitutional right to have access to information. While in Europe, we notice a different attitude, the different attitude that I just mentioned, the fact that we see constitution specifically referring to different situations as individual rights. And so this creates an important question that we need to address if we are talking about an exhaustive catalog. So if we can't recognize the existence of free speech rights or speakers' rights, except for the specific situations mentioned under the constitutional umbrella. And this is also an interesting point we want to address in light of the digital evolution. We know that access to information is one of the most important part of this. It's a precondition for individuals in order to exercise the profile that is freedom of information. They want to research information, they want to seek information, so they need to have access to information in a way. And so, as you know, there is a large debate on the freedom to have access to the internet or to media, generally speaking. It's an important point to consider. And once again, we don't see in constitutions apparently a very specific reference to that. But we need to work a little bit in order to understand if the constitution implies in an implicit way the existence of such right. And this is, of course, very connected to the fact that sometimes we see open-ended clauses, and as opposed to clauses that are apparently more exhaustive, and basically refer to different possible means of exercise. This is still a point we want to stress very well. We can go to the next slide. And I think it's yes. Also, in the comparison between US and Europe, we want to stress the important difference we see in the hierarchy of rights, because maybe we don't consider sometimes in the academic speculation that we see on the subjects the different attitude of the legal systems and the relevant constitutional law to freedom of expression. I mentioned before the fact that there are specific limits, such as the important limits placed by the dignity, human dignity in certain jurisdiction. I mentioned the German case, the importance attached to this limit in the Bundesverfassungsgericht's case law, because by the constitution itself. But we must not forget the idea that in the constellation of rights, sometimes we have a specific preeminence, the preeminence that reflects in the different attitude to strike compromise and to balance this right with other possible rights. So while in the US, we see still a predominant value for freedom of expression, in Europe, we notice this is probably different. We notice that there is an important attitude of courts to strike balance between the possible rights and also between the possible profiles of the freedom of expression. And this is also reflecting the latitude of the protection that is afforded to individuals. Next slide, please. I don't need to, let's say, spend much time on the European Convention of Human Rights. Many of you are familiar with this system, but just take a few seconds in order to understand how the European Convention on Human Rights and the Court of Strasbourg are, in a way, providing a paradigm of protection that is, of course, is binding for every European state. The focus also in this case is on the freedom to hold opinions, and also if you look at the case law and of the European Court of Human Rights, it seems that the right to hold opinions is in a way a precondition for the exercise of other freedoms, meaning that there is a predominant value. It's a precondition for the exercise of other possible profiles, because it goes without saying that the mechanism provided by the second paragraph of Article 10 cannot be applied per se to the freedom to hold opinions. How can the state interfere with your right to have opinions? That would be, of course, something that is not permissible. It's even something that in practical terms is of course very difficult to accept. And so when we look at this possible wording of Article 10, I think we must recognize that the freedom to hold opinion is the paramount right here. And of course, we have some important restrictions that may be provided in accordance with the second paragraph of Article 10 with respect to the other two profiles, the freedom to impart information and ideas, and the freedom to receive information and ideas. I mentioned before this information, that one of the possible justifications for the contrast or for the measures countering disinformation is the fact that the Article 10 is referring to the right to receive information. And some constitutions, for example, the Spanish Constitution, Article 20, is providing a very specific wording like accurate information. So if we mention accurate information, it seems that we are creating the grounds for having something more than just a free flow of information. We are creating grounds for lawmakers and regulators to dig a little bit more into this and to preserve, in a way, the public debate from inaccurate information, at least. We can go on this. And also, I think that's an important, this was just an interlocutory slide. Thank you. That's okay. It operates, as I said, the right to hold opinions as a precondition. And apparently the limitation, the restriction, as I said in the second paragraph, are incompatible with this idea. So the question that we want to address today in particular is having ascertained that there is the specific framing in the relevant supranational law and in the relevant constitutions we were examining. How does this change? How is this affected by the rise of the digital age, where we notice the existence of different actors involved in the content moderation, in making available forums and spaces for the public debate? That's the question we want to address. Moving from what we have seen before, moving from the fact that each constitution may incorporate a different view, may have a different attitude to certain means, to certain activities, so holding opinion, sharing information, sharing accurate information only. And now reflecting basically also in the private public dynamic. That is an important point, that one of the four factors I mentioned at the beginning. So, and also bearing in mind the importance of the different limits each legal order may place. I made some examples. I just quoted some judgments of the Bundesverfassungsgericht in the next slide. I think you can find some examples just to tell you how, in a way, the German Constitutional Court managed to go beyond the reference that the Article 5 of the Basic Law provides to what is the right to express opinion. So creating a broader interpretation, creating a more, let's say, solid base for the more robust protection for freedom of expression. We can go through the next slide. I just want to show, I think it's okay. We can also go ahead. Yes, we can also go ahead on this. Yes, thank you. We made some examples on the attitude of the European Court of Human Rights to look at the difference between value judgment and statements on facts. That is an important point to consider in the debate regarding disinformation. Just to say that sometimes you notice that European Court of Human Rights has a specific approach. Domestic courts may have a more specific one. If you look at the German attitude, you can notice how the Bundesverfassungsgericht managed to go beyond the limits that the wording of Article 5 places on the protection of these rights. So how this constitutional freedom is protected even in a broader understanding, even according to a broader scope of application. I mentioned here some of the possible examples, some of the most important judgments of the Bundesverfassungsgericht. looking at her liberty to speak his or her mind freely, whether or not the speaker is able to furnish verifiable reasons for such judgment, or the right to express opinions, to persuade and exert an intellectual influence over another person, and important reference to the idea that the purpose is to persuade, to convince others. So every effort you make on that perspective is, of course, protected. The fact that it is relevant whether opinions are valuable or worthless, correct or false, justified or emotionally or rationally, and the reference also to possible harsh words or fighting words if used in the context of political battle of opinions. That if you look at these judgments, we notice the importance of going beyond the wording, going beyond the simple reference to a right to disseminate opinion according to Article 5. And we notice also the importance attached to personal honor and to the right to dignity in that specific. Next slide, we can also notice some references to disinformation that, of course, are useful in our view. False information is not an object worthy of protection from the viewpoint of the freedom of opinion, and the deliberate assertion of untrue facts is not protected. That said, we can also compare the German understanding with the Italian one when we have more or less the same approach. The idea that we are not supposed to ban or prohibit the expression of false statements, but it goes without saying, this does not imply the existence of an obligation for the state. This only implies the fact that those statements are deprived of constitutional coverage, the constitutional protection, the fact that you can say something that is false, that is maybe reflecting your views on certain subject matters, but it's not per se prohibited. It's not per se a crime or an unlawful conduct. It's just something that is not protected constitutionally. So it means that regulators and lawmakers can, of course, interfere with the expression of those statements, can also interfere because they are not affecting your constitutional right as speaker to say something that is false. In the Italian scholar debate, this is even more sophisticated as the viewpoint of a very famous scholar, Carlo Esposito, was very influential. He tried to draw a distinction between the cases when an individual was asserting certain things on the basis of the opinion that those statements were true. So what is true in the view of that speaker, differentiating those statements from those expressed according to a specific deliberate purpose to say something that is false. So based on the fact that there is a difference between what you know is true or not and your personal and voluntary action. So that's basically a more sophisticated view, but the idea is still that we don't see constitutional protection for that. And so the question that I think Professor Pollicino will address in the next part of this presentation is, once ascertained that this is the status quo and that we notice that constitutional courts and lawmakers can, in a way, do very important things in order to broaden or even restrict the scope of application of free speech, the question is, okay, that said, how things change, how this public debate that is shaped according to a quite broad view in Europe, even if we are still talking about rights, specific rights granted to individuals by constitutions, how this changes in the digital age, how this change when you are not only dealing with the state and with public actors, but you're dealing with private actors. And when you are sharing your thoughts, even in a broader sphere, when probably the risk to create some harm is higher compared to the normal sphere in the real world. That was basically the question we tried to frame. So I think next slide will be on the metaphor of marketplace of ideas. Yes, that's okay. So I leave the floor.
Thank you very much. We can go in a slide before, please. And exactly. Thank you very much, and thank you, Marco, and first, a great thanks to Charles, because he is a great, really laboratory in action of constitutional ideas and migration of constitutional ideas. And in a way, we are dealing with migration of constitutional ideas in relation to freedom of information. And as Marco very successfully was able to frame, basically, we are dealing with a much more complex scenario that is based on at least three moments: the actors moment, the space moments, and the values moments. These are, I think, it's important triangle: space, values, and actors. Why? For the reason that you read in the slide, you know very well. First of all, beside what Marco said, there is a great atomic nuclear bomb, let's say, or that is the Drittwirkung horizontal application of fundamental rights in Europe. And this is also true for the application of fundamental rights in the digital context vis-a-vis private actors. This is very important because it's, and we can go to the next slides. This is something that is very different from the United States constitutional spirits and what is called the state action doctrine. That in a way, it's very important also for the digital age. Why? Because basically, as Marco was very clear in saying, the Bill of Rights and the amendments of Bill of Rights are not applying vis-a-vis towards the private actors, because as it's, let's say, in the cultural humus of United States constitutionalism, states should do a step, maybe even two steps back, in order to basically favor the horizontal judicial interaction. Okay, but all this, how it's applying to freedom of information and moving from values to space. I think this is also a very important issue. Why? Because space, in a way, are framed by words. And as Marco said, quoting that famous movie, words matters. And especially the words pronounced by judge in framing metaphors, and then how those metaphors are framed and are basically borrowed, for example, from one part to the other part of the Atlantic. Let's try to focus on the first metaphor, the most important, the legendary one, marketplace of ideas. We know very well that it was framed in 1919 by Justice Holmes in the dissenting Abrams versus United States. And the idea, it's very obvious. The emergence of truth, it's basically the result of the public confrontation of different points of view, basically different perspectives. Among those, there could be also a false perspective that is basically competing on equal foot with the true ones, which are the policy implication of such metaphors. That basically, according to the marketplace of ideas, it's true that in the First Amendment, or at least in the light of the First Amendment, there is not such thing as a false idea. This means that, in other words, public authorities should not have any role or a very minimum role in dealing with the ever-growing phenomenon of fake news. Why? Because basically there is a trust, a digital trust in the capacity of self-correction, of self-healing of the market of information. Now, moving to the next slide, why it's very important to handle metaphor carefully. Because metaphors, as you know very well, better than us, because we have mostly of you have this philosophic background, the cognitive background. Metaphors implies knowledge transfers across domains, from the Greek metapherein, to carry over. What does it mean? It means basically that we have two different constitutive domains in the metaphors: the source domain and the target domain. The free marketplace of ideas carries over from the source domain of economic activity, antitrust, to the target domain of speech. And this is very important because when Holmes framed this metaphor in 1919, and then when the Supreme Court in the Reno judgment that was mentioned by Marco in 97 basically reframed the metaphor, saying that the internet was the new free marketplace of ideas. In those two different moments, there was something in common. The things in common was basically that both the economic market and the markets of ideas in the internet were free, or at least were enough free to enhance the free marketplace of ideas. Now, when the same metaphor has been borrowed by many scholars in Europe in order to basically defend the self-regulation approach in the fight against disinformation. And I was present there because when I was at the European Commission, there was this debate among scholars and experts. Shall we borrow this metaphor, or shall we try to find another definition, another, let's say, value perspective according to the European constitutional humus? According to some scholars, the good idea was to borrow the metaphors. But in borrowing the metaphors, being different the values. Why? Because we said that First Amendment not only as let's say, of a quite undefinite scope of application, but it's especially focusing on the active freedom to impart information. Whereas not only in Europe, freedom of expression is playing, let's say, on the same ground, on equal feet with other rights, but especially is the passive version, right to be informed, that is very important. So different values, different times, a different markets, a different concentration of market, all these basically difference made a kind of misuse and abuse of this information with huge implication of policymaking, which huge implication theorizations of the best, I would say, best reaction against disinformation. Now we can go to the next slides. Even the next, please, because it's important, slide 20, to focus on the idea of public forum. Why? Because again, words matter. Again, it's very important to understand if a kind of, let's say, statement has a normative values or just, I would say, descriptive values. And now the second statement that is now quite a la mode is that the digital space hosted by digital platforms in order to basically have also an exchange of information. So basically a space in which the right to be informed, the right to inform is exercised. Those spaces should be a public forum, should be or are supposed to be a digital agora. Now, why it's very important is because even the Supreme Court of the United States, even if it's just confirming the statement according to which digital platforms are still not state actors. This means digital platforms are not supposed to basically seeing enforced the Bill of Rights and the First Amendment. So they are outside the scope of application with regard to the application of First Amendment because they are not state actors, and we know what does it mean, the state action doctrine. But despite this, those spaces are basically moving from a private zone to a kind of pseudo constitutional or public dimension. Now, this is very important because if this should be taken seriously, if this move, if this shift should be taken seriously, then the consequence would be that those spaces in the electronic media are in a way basically part of the application of the public forum doctrine, according to which even the private platform should not are not supposed to do any kind of discrimination or differentiation on the basis of the merit of the opinion. Why? Because it would be a viewpoint discrimination, so no discrimination would be allowed. This means basically that would be a kind of strict scrutiny that is the same related to the public forum, the public space, the public dimension. Now, this is very important in order to understand if there is this shift, and if this shift is just in words or is also in relation to the normative dimension. And I think we have two main decisions of the Supreme Court that can be in a way be taken as example. The first one is Buckingham, the Buckingham case that involved the test of North Carolina, I would say, almost draconian law preventing anyone on the sex offender registry from ever using any kind of social media. Footnote: this definition of social media was incredibly broad, including also websites like Washington Post. What basically the Supreme Court is saying in this decision is that the cyberspace is the vast democratic forum of the internet, and social media in particular. Now, why it's very important, this decision, and Marco Bassini wrote a very interesting paper on it, because even within the court, there was the debate in relation, shall we take seriously this upgrading of private forum in a public one, or it's just a undisciplined, or it's just an undisciplined dicta, as Alito said. So basically the point was, this is just something that was not intended to have a normative values, or it's really a shift from a private space to a public space. And this was the concern of Justice Alito, that basically asked to the majority, and especially to Justice Kennedy, to clarify this point. And the point was not clarified in the narrative of that judgment, but was clarifying the narrative on another judgment of this Second Circuit, Court of Appeal of Second Circuit. It's Knight versus First Amendment judgment that versus Trump, that in a way, it's basically in a way trying to clarify the point. By saying that we do not consider or decide whether an elected official violates the Constitution by excluding person from a wholly private social media account. This was basically the decision of Trump from its account to remove a user, being a space owned by a state actor in that case, because it was Trump, clearly, in that case, was considered a public forum. But what the court is very keen in specifying in that case is the First Amendment does not permit a public official who utilize a social media to exclude person. But we are not dealing with the issue if removing a user from a space not owned by a state actor, it's basically a restriction related to the public forum doctrine. So basically, it's quite clear that the statement of the court, of the Supreme Court, was not a normative one, or maybe we have some evidence that it was not. And this is very important because we can go to the next slides. What is very important is basically now to understand how those concepts, how those, let's say, metaphors should be handled carefully in order to not create misuse, in order not to create abuse, in order basically to not create a narrative that is a little bit problematic in terms of protection of fundamental rights. Now, what next? I think, and we can go to the next slides, that basically the most important point is to focus on not only the fundamental rights at stake that are related to a value-based rights, like dignity versus freedoms, on equality versus dignity, and so on. Because if we keep insisting on substantial issues like we did, because in a way we are forced to do, simply because there are two different constitutional humus, two different, basically, I would say, paradigms in relation to freedom of expression and freedom of information in a transatlantic relationship. This is something that we should do, but we should combine this, I would say, value-based perspective to a, I would say, procedural perspectives. What does it mean? It means also looking at the new digital package reform of European Union, the Digital Service Act, and the other package. I think that we should try to focus on the procedural issues. That means basically to focus on the rights and on the remedies of the users vis-a-vis platforms. That means right to access, right to claim transparency, right to claim explanation, right to be heard. This is very important. It means basically to apply horizontally Article 6 of European Convention, where basically there is the issue related to the fair process that in a way that in a way is characterizing also the procedural dimension of the relationship between platforms and users. And why I think this is very important, because I think it's an element, it's an issue that can help in making the distance that we try to let emerge between the two sides of Atlantic less distant, a little bit closer, because the procedural side, the due data process, it's something that is in the DNA also of United States constitutionalism. The due data process is something that is not unknown. And this is, I think, should be the next perspective. This does not mean neglecting the difference that we are trying to let emerge, but to complement this kind of, I would say, value gap with the procedural season that in a way can be a bridge that at the moment is lacking. Thank you very much.